20 years ago, when I started out, it was 10, well, I can't tell you, 8, 10-year wait. Now you get a jury trial like it's just easy. Granted, mediation and arbitration have helped alleviate that problem. But why do you think that so many of these cases come back to time?
I think largely public cynicism mixed with some amount of compassion fatigue, they used to call it. I think the case has to be pretty compelling before juries will take interest. If it's soft tissue, what we call soft tissue, cervical strain, lumbar strain, if the medical providers like chiropractors, I think the jurors look at that with some skepticism. Because after all, the complaints are subjective. There's no MRI or X-ray that can demonstrate it, so that the credibility of the plaintiff then becomes paramount. The jurors have to either believe they are suffering or not, and I think that more likely than not, they find that a failing on the part of the case. My way of analyzing the case was, first of all, who's the money going to? Who's the money coming from? And what will the money do? So that if the money is coming from someone with deep pockets, corporation or whatever, you're more likely to get a judgment. If it's going to someone who the jury likes, who seems innocent, like your passenger, or someone who seems upright, and if there are things that the money can do for the person, do they have needs that if the jury did not make an award, it would bother them later when they reflected on the case. It would bother their conscience that, gee, this person didn't have the van that they needed, or this person never got the visiting nurse that they needed. So, but going back to that point about jury instruction, there is one particular jury instruction that bothered me for all time when I was on the plaintiff's side of medical malpractice cases. Judges consistently would give the plaintiff, would give the defendant the instruction that a physician is entitled to wide discretion
made that argument to several